My brothers and sisters, we are picking up a pattern that I want to lay out for you because all the gun control laws that have been introduced over the past year to a year and a half in the face of the Bruen decision, I'm picking up something very interesting, and I'm sure you guys are going to get a kick out of it as well because it looks like they're all painting themselves into the exact same corner, which makes them heavily on the defense. Now, everything will be linked into the description box below, and let me know if I land this plane because this one, I think we're onto something. And of course, make sure you like the video, subscribe to the channel, and turn the notification bell on. And if you've been here for a while, just double check that subscription's active because we've had hundreds of people who have magically and accidentally gone offline. So anyway, that's what I've got for you. Let's dive into this because this piece of content that we're about to dive into is spurring from New Jersey, but there's also a parallel case that's happening in California, in San Jose specifically. Now, what I'm about to show you is how these cases against gun control, marketing specifically, and infringements are getting dismissed, but not for the reason, not because they're not constitutionally sound, but because they're done too early and there's no injury. Check this out. Like I said, let me know if I land this plane, but there's something to this. Appeals court dismisses challenge to New Jersey gun liability law. Now, this came out about an hour ago out of New Jersey. Now, this is stemming from the exact same thing, the liability, the marketing clauses, all the pieces that hold gun dealers and gun manufacturers accountable for things that are not their fault. This is the workaround and the end run around the PLCAA, which is the Protect Full Lawful Commerce in Arms Act. This particular case I'm about to show you is a NSSF case. The SVP and General Counsel of NSSF wrote the PLCAA. He was there when it was passed, obviously. This is important because, let me get through this and you guys tell me. A federal appeals court on Thursday dismissed a lawsuit challenging a New Jersey law that creates a pathway for the state to sue the gun industry. Like I said, it's all about that liability shield being dissipated on the state level. A three-judge panel on the U.S. Court of Appeals for the Third Circuit ruled the lawsuit brought by the NSSF, a firearm industry trade association, was filed too early. Put a pin in that, as we're going to come back to that. The group challenged the law before enforcement began. So, this is about timing, not about constitutional or not constitutional. Again, we're about to hit on the San Jose situation for California. I'm going to tie this all together. Quote, but we see little evidence that enforcement is looming. This is from the court decision. Because the foundation has jumped the gun, its challenge must be dismissed, Circuit Judge Stephanos Bibas, a Trump appointee, wrote for the panel. The law, which passed last year, enables New Jersey's Attorney General to sue entities that manufacture, distribute, sell, or market gun-related products if they contribute to a public nuisance. This is one of the big new things from the left. This is what they're trying to do, sue you out of existence through public nuisance laws. They're always going to try to do something, but this is the newest flavor of the week. Now, this is what happened that led to this. The trade association filed the lawsuit in November before New Jersey's law went into effect, and a federal district judge blocked the legislation in a preliminary decision. So this already got an L. This was already preliminarily enjoined. This was blocked by another judge, and this three-court panel just overruled it. Now, the reason why is the important piece. This is the timing aspect. Now, I'm going to pause this for a second. Let's zoom out to San Jose, California. They instituted mandated gun owner insurance, mandated fees if you're going to own a gun. The entire case, which was brought by NAGR, or National Association for Gun Rights there, was based around the premise that it's unconstitutional of what they're doing to gun owners in that city. The judge there said, no, we can't do this because they have not enforced this law yet. There is no injury. There is no enforcement. So we can't keep going. It's dismissed. When they enforce it, you can come right back. Now let's zoom back to New Jersey. This is the exact same thing that these judges are saying. It hasn't been enforced. It could be unconstitutional, but until there's actual injury, you jump the gun, so to speak. What I'm kind of going at from this entire video is these gun control laws that are being instituted for marketing purposes, for manufacturing purposes, to sue under public nuisance laws from these zealots on the gun control left, they're all being dismissed because of timing, not because of grounds. This is very important because what this does is it puts it in place that if this becomes enacted or becomes enforced, you're going to go right back to the exact same court cases. Check this out. This is why it's really crucial to look at the entire playing field. The judge ruled New Jersey's law was preempted by a federal statute. This is the first judge, passed by Congress in 2005 that protects the gun industry from liability when others misuse their products. The trade association had also raised the Second Amendment and other constitutional challenges in their lawsuit, but the judge did not weigh in on these claims, did not weigh in on those claims. It violated the PLCAA. That's why it was halted. New Jersey Attorney General Matthew Platkin, extreme anti-gunner for the record, appealed to the Third Circuit, and the panel agreed the lawsuit was brought too early. Again, too early, not no grounds. This is what they said. Quote, pre-enforcement challenges are unusual. To bring one, the plaintiff must show that the stakes are high and close at hand. Normally, that means constitutional rights are at issue. Those rights are threatened by significant penalties. And those penalties might well be imposed as shown by past enforcement in similar situations or some other evidence of the threat, Bibas wrote. Again, it's about enforcement and penalty. It's not about unconstitutionality and timing. That's what this is about. They are painting themselves into a corner. So if they enact this, or if they take this under consideration, or they make a move on it, they've already got previous court cases that say we can't talk about this until there's injury. They make one move, there's injury. They have painted themselves into a corner by saying, no, it's not enforced. We can't be in trouble. San Jose, New Jersey, they're all doing the exact same thing. So they pass a gun control law. They get to pound their chest and build their bona fides for the gun control movement. And then when they don't enforce it, they don't get in trouble. And that's their argument in court. But the second that they enforce it, they become in violation of the court, of what they're talking about. Not the court decision, of what the court discussion was. This is how they're painting themselves into a corner. Again, I hope I'm landing this plane, but I got one more thing for you. Actually, two more things for you. This is what the NSSF said, and this kind of paints what I'm saying here. While we respectfully disagree with the court's decision on our pre-enforcement challenge, it is important to note that the court did not say New Jersey's law does not violate the PLCAA. It clearly does, Keene said. During oral arguments, the panel appeared to have concerns with the law, as did the district court that enjoined enforcement. Should New Jersey's Attorney General attempt to enforce the law, we will immediately refile our complaint. And that's kind of what my point is. And then I got one more thing from the Attorney General. The whole point here is they're now painted into a corner. Well, the court case got dismissed because of timing, and it's not enforced. The second that you enforce it, we're refiling it. What are you going to do? So now it's a game of chicken. Here's what they're going to do. Here's what the Attorney General of New Jersey said in response. This is not over by a long shot. Quote, we are thrilled that a unanimous Third Circuit panel rejected the challenge to New Jersey's public nuisance law, which allows our office to take on bad actors in the firearms industry, Platkin said in a statement. Our law never should have been enjoined, and now it will be back in effect in its entirety. Okay, so you're going to throw it right back onto the court to be played with, and you're going to enforce it. Okay, well, let's see in court once you enforce it. And again, that's the entire point. They're painted into a corner. They either can't enforce it, or they enforce it, they go back into court. They're not exactly in a winning position there. And that's what I've got for you guys. Let me know what you think in the comments below, and I will see you on the next one. I'm Braden. See you later.